office hours, if you're putting together your study guide and you want some advice, bring it to me or Dan or Sadie, and we're happy to help with it. So today, let's talk about the Uniform Commercial Code. This is an area of the law that's going to be important to you guys, and yet it's an area of the law that a lot of people and a lot of lawyers don't fully understand and just don't think about, okay? But it actually is going to impact what you do if you are in the business of selling any stuff, okay? Before we get into when it might apply, let's talk about this idea of a model law, all right? So there are groups of smart people out there who will get together from time to time and they will draft model laws, okay? The American Law Institute is one of them. It's a group of law professors and legal practitioners and other folks who attempt to create templates that can be used all across the United States. All right? So when they get together and they create something, whether it's a UCC or whether it's some model legislation that can be used for business entities that we'll talk about in the next chapter, it essentially is a reference or a guide or something that states can use or adopt or adapt if they wish to. However, a model law, until it's adopted by a state, doesn't have any legal form or effect, okay? So you get these folks together, they draft these things, and they come up with something, and they say, ta-da, here it is, okay? This is what we think is going to be a good law for all the states to adopt. And then each state can choose to say, no, we don't want your model law, we'll write our own laws, thank you. Or they can say, yeah, we're going to adopt it as written, we're just going to fill in Iowa, wherever it says, blank. Or they can say, yeah, this looks good, but we're going to add some things too, or we're going to modify this, okay? So a model law doesn't have any legal effect until it's adopted. The UCC, as we usually talk about it, is a model law. However, every state has adopted some version of it, okay? I'll show you a little bit of Iowa's without getting too deep in the weeds. What is the UCC intended for? Well, it's a set of rules that focus on the sale of goods, primarily in a business-to-business or a merchant setting. And then there's other stuff that has to do with banking and securities law in the UCC, which we're not going to touch at all. Okay, we're really going to concern ourselves with that first part, the sale of goods. And I think the other thing that you have to know is that this UCC, when it applies, it modifies the common law rules of contract. So I've told you over and over again, most state law most contract law is state law. You have to know the cases in that particular state. You have to know the rules of that state as far as how the judges have applied different provisions. Now I'm saying there's this other overlay that you may have to know as well. And this is where a lot of attorneys who are not necessarily business attorneys get into trouble, because they get into a transaction and they're trying to use the common law and they don't know that, hey, this is actually under this special set of rules. And if you're going to be in business or go into business for yourself, you have to know when this stuff applies as well, because it changes the rules considerably. So if you see a situation with some kind of commercial transaction, that's generally when you're going to start thinking about, is this a UCC setting? So like business-to-business stuff. A supplier is selling to a manufacturer, or somebody is selling, raw materials to, some kind of factory that's going to convert them. Okay, that might be a UCC situation. When you have merchants selling to other merchants, so like a wholesaler selling to a retailer. And then when you've got merchants selling to individual customers, so in a retail or a direct sales setting. These are areas where you start to think, does it apply? Iowa has our own version of the UCC, and we took it and copied and pasted it and then added and subtracted and modified some things, and it's at Iowa Code 554. If you have a lot of time on your hands, which I doubt you do, you could click through and read some of that. I've just reproduced part of the table of contents of part of the UCC here on the right. All that blue text, each of those is going to lead you to a whole new section of the law. Okay? I guess what I'm saying is there's an awful lot there. Thankfully, you don't have to know all that stuff. You don't have to read it. I've never read the whole UCC, okay? But I think you have to know when you might be in that realm, so you shift your thinking a little bit away from just the common law version. And in our version of the UCC that we've adopted, it says right up front, this chapter must be liberally construed and applied to promote its underlying purposes and policies, which are to simplify, clarify, and modernize the law of commercial transactions. So that's one purpose we have here, is to make things easier to understand, to bring it up to date, okay? What if every time you had a commercial dispute, you had to go find the Iowa equivalent of Sherwood versus Walker, the Barron Cow case, right? I mean, it's bad enough to have to know the written laws. How do you know all the cases, too, in every state? What if you're going across states, right? So it's modernizing it, simplifying it, clarifying it. To permit the continued expansion of commercial practices through custom, usage, and agreement of the parties. So in other words, this is one of the few, I guess, areas of American law where we encourage customary law or practice of an industry to be legal and, in other words, to be more adopted. So normally we see regulations come from lawmakers down to the business level, and that law changes business. This is one of the few examples where we say, okay, we're going to specifically allow business to change law. All right? So if there are different points where there is a really clear pattern or practice in a certain industry, instead of saying, well, okay, you've got to take this long-established practice and hold it up to the law, and if it doesn't fit, you've got to throw the practice away. The UCC is saying we're going to honor and recognize some of those things because that reflects the reality of what's going on in the industry, okay? And then the third point is to make the law uniform among the various jurisdictions. So imagine the difficulties in dealing with contract law across different states. I've had to do this, where I have people from other states that have a contract dispute with my client, and if we've done our job well, the jurisdiction is going to be in Iowa. They're going to have to dispute it under Iowa law, but I've had situations where I've got an attorney from Phoenix saying, well, you know, our statute of frauds says anything under this is the right amount, or, you know, an oral contract can exist for this under Arizona law. And I'm going to say, well, in Iowa law, we've got this case, and it says something different. Okay, so a UCC kind of law, a uniform law, we're dealing hopefully with pretty much the same thing. Now, each state might move provisions around, they might renumber them, as Iowa has, but for the most part, it's going to be the same. Okay, so I can talk to somebody in a different state and say, yeah, I understand you know, we're both under the UCC. Here's how the transaction is going to go. Now, there's 9 different articles or divisions within the law. All we really care about is Article 2 for this class. So there's kind of general definitions, Article 2 sales is what we care about. There's stuff on leases. And then there's all this banking and credit and securities stuff. And if you want to be a securities lawyer or you want to specialize in secure transactions, you can take a class on that. Honestly, I don't know it, and I'm not going to teach it. Okay? What I do know and understand and what is important is the Article 2 stuff. And that has to do with the sale of goods. All right? So we're taking things back to a real basic building block of transactions here. The sale of goods. All right? You say there's 3 words in sales of goods, and I know what of means, so this has got to be like the easiest thing to interpret. Not even a lawyer could disagree on what that means, right? Au contraire. Of course lawyers can disagree. So how do you break down what a sale is and what a good is? Okay? Well, sale means that some kind of legal title passes from seller to buyer for a price. All right? So we've got some elements in there. So it's not a lease, it's not a gift, because that gift wouldn't have a price involved. But this is still pretty clear, okay? Does ownership change hands in exchange for a price? Goods means items that are both movable, you can take them from place to place, and tangible, you can touch them, all right? Almost easier to define this one by exception. So we're not talking about services under Article 2 of the UCC. If you are an accounting firm and you are selling your services to another business, not going to be covered under here. You're still going to be under the common law of contracts. But any kind of goods will be under here. Real estate is an exception. It's not a good because you can't move it. You could pick up a handful of dirt and move that, but you can't move the land that's there, okay? It doesn't cover intellectual property, like copyrights, okay? That's not a thing you can touch and hold. It's an intangible. Shares of stock, that's different, covered under different parts, not Article 2. What does it cover? Things like livestock, books, lumber, crops, appliances, things you can hold in your hand and move. What if a contract involves both goods and real estate? I had to ask that, of course. Well, that's a situation then where the court gets to decide, is it more of a land contract or more of a sale of goods, which is more important, okay? But let's simplify things and just really think about the sale of goods. Now, if you're in the business of selling goods, you might qualify as what's called a merchant. And merchants have certain rules, special rules, that they have to follow under Article 2 of the UCC, okay? So who qualifies? Well, somebody who deals in goods of the kind. So if you're selling, I don't know what this guy is selling, looks like rugs and maybe things that come in little drawers. Say he's selling spices, okay, and rugs. So that's his business. He's a merchant as to those things, all right? Or if a person holds himself out as having knowledge or skill peculiar to the practices or goods, in other words, special skill. And then there's a bunch of other language that basically says if you act like you have a special skill or knowledge as to what you're selling, then you're a merchant. So examples of this, a jeweler, an owner of a grocery store, the owner of a lumber yard, okay? These are folks who are in business to sell those things, and they have some special knowledge. So you selling one bicycle at a garage sale or on Craigslist is not going to qualify you as a merchant unless you're in the business of regularly doing that, right? If it's kind of a one-off thing out of your area of expertise, that's not going to qualify you as a merchant. Somebody who habitually sells this kind of stuff is, though. And because we see them as having some special expertise, we're going to hold them to a little bit higher standard when they deal with customers, all right? So there's some extra legal duties that they have to follow. There are also some different things about agreements that are made under the UCC. And this is where I feel that the UCC really kind of improves on this patchwork common law system that we have for most contracts. So one of the things that is unique in the UCC is it requires folks to, the parties to a contract, to perform the obligations under the contract, quote, in good faith, honesty in fact, and reasonable commercial standards of fair dealing. So sometimes we just call this the duty of good faith and fair dealing, okay? You're saying, is there not a common law duty of good faith and fair dealing? It could depend what state you're in, but generally it's kind of every party for themselves, okay? Under the common law rule, I think courts are going to take a much harsher approach. However, under the UCC, they're going to read in this increased duty that, yeah, you gotta enter into your agreements and comply with them in good faith, fair dealing, honesty in fact, okay? And it sets some standards for merchants that the average person doesn't have. Commercial standards of fair dealing when they conduct business with other merchants or with their own customers. If you're selling your bike on Craigslist, this doesn't apply to you. You don't have a commercial standard of fair dealing for a one-off transaction, okay? So if you sell something with a defect, there's going to be a lot less recourse, fewer remedies for the buyer. Whereas if you're a merchant, if you own a bicycle store, you sell a bike to somebody and it has a defect, you're going to be held to a higher standard, okay? UCC, perhaps most importantly, can fill in the gaps in contracts, all right? And this is one of the ways that it also really shines. So I showed you a whole bunch of ways how a contract can fall apart in the previous two modules, okay? It's not in writing when it needs to be, or the terms aren't specific enough, or maybe somebody hasn't signed it, or there are these other technical problems with it. The UCC goes in and tries to kind of fix some of that and fill some of those gaps, okay? And I know it's kind of weird to think about because I've told you like over and over how important contracts are and how you have to look them over before you read them, okay? And if the Facebook testimony in front of Congress this week is of any indication, I was listening this morning to some of the testimony that Mark Zuckerberg gave yesterday, and the congressperson asked him, isn't it true that you trade in people's personal medical data? And he said, well, congressperson, if they share it with us, we do. Okay, I was like, well, that's a little, and they said, don't you observe people who aren't even members of Facebook and gather their data? Well, if they share it with us, okay. Their approach through all this has been, if you click accept on the terms and conditions, fair game, right? And so there's a little bit of a tangent here, but what I'm trying to point out is I'm always saying contracts are really important and you should read them carefully before you sign them. Now, when you're a merchant and you're selling goods, maybe you're buying raw materials, you're converting those into finished goods or some kind of component that you're going to send on, you've got invoices and purchase orders and contracts and agreements going every which way. You might be signing many of these a day or negotiating many of these a day. And sometimes you forget stuff or leave stuff out. Now, under the common law rule of contracts, they would say, well, you forget to sign it, maybe there's no contract. You forget the quantity term, well, totally unenforceable. Forget the price, forget it. You had no meeting of the minds, right? The UCC comes in and just kind of fills the gaps and smooths over a lot of those rough spots. Because remember, one of the underlying purposes is to promote business, to do more business, not less. Okay? So sometimes parties are going to forget to put in things like when the goods should be delivered, who's going to replace the defective goods, and a contract for the sale of goods under the UCC can still be binding even if some terms are left open, either because they forgot to fill them in or because they intended to keep those open for discussion later. So here's a little rundown, or a cheat sheet, if you will, on what happens if you leave some of those things out. Now, it would seem to me that for most contracts, the price is going to be like super important, right? Okay, if you don't know what you're paying for something, can it really be said that you have an agreement? In some cases, the UCC will say, yeah, both parties intended to make this transaction. We'll make that contract enforceable, and we'll let the court determine a reasonable price at the time of delivery if it should go to the court system. Okay? What about payment terms? So, some contracts are going to say payable on delivery. Some are going to say 15 days, 30 days, maybe longer, right? If you forget to include payment terms, the UCC is going to plug in there that it's due at time of delivery. What if you forget to say where the goods are supposed to go? Well, the default is going to be they have to be picked up at the seller's place of business. Okay, if you forget to put that in. Now, what about quantity? You're saying these two parties didn't put together enough of an agreement to say how much? Can this still be a deal? It can under the UCC. This one is probably the least likely to be gap filled, if you will. But there are times where the court might look at it and say, okay, the custom between these two entities was that, the company A was in the practice of buying all of company B's output. So we're going to read that in. Or company A was in the practice of buying X amount a month, and they'd done that for so long, so we're going to read in that amount, okay? So the whole idea is that the court can if someone brings an action on the contract, the court can possibly fill these things in by looking at either these default terms or the course of dealing between these two parties, which they would introduce evidence of with previous agreements, or these standards in an industry. So again, trying to keep the flow of commerce going rather than saying, no agreement, everybody go home. All right? Some other changes as well. This awesome clip art here signifies what's called the Battle of the Forms. All right, so I told you about this mirror image rule, which is a very persnickety detail, if you will. Under common law, if somebody specifies terms in an offer, you can accept that offer by accepting all their terms, and that's the only way you can accept. If you try to vary terms, that becomes a counteroffer, right? Like we talked about, somebody offers you $100,000 a year for a job, and they offer you 5 days of vacation, and you counter and say, I'll take the $100,000 and 14 days of vacation, thank you very much. Okay, have you accepted? No, you've counteroffered, which is a rejection. You can understand how that kind of paradigm would be bad for doing business, okay? Especially when each company has its own forms they like to use, right? Most large companies are going to have their agreement. When my clients do business with a major casino or a major retailer or something like that, I look at it and chances are very good those big companies are going to have their own form that they want everything on, all right? And we have our own forms that we use too. If we were in the realm of buying and selling goods, the UCC would allow for some flexibility in there. So it suspends that mirror image rule and says we're not going to be that particular on details, Okay? So if you are kind of sending forms back and forth in the negotiation, and it ends up, whatever the final agreement is, that there are some mismatched terms, if in the discretion of the court those can be resolved, then the deal will be upheld, rather than the very strict mirror image rule, which normally they would say, no deal, start over. Okay? So, like minor things like time of delivery or something like that, mismatch here in the example, that could be kind of smoothed over by the UCC. There's some changes to how offers might be made. Okay? If a merchant makes a firm offer in writing, then under the UCC, if they can either specify a certain length of time, or the UCC might read into like up to 3 months for that offer to stay open. Okay, and if you say this is a firm offer, I will provide these raw materials at this commodity price for, you can accept this at any time within the next 14 days. You make that firm offer under the UCC, it has to stay open that long. And that's different than the common law rule, where after you put out an offer, if the other side has not accepted, you can yank it back. Okay, so this is going to keep it open. We talked a little bit about this tricky situation where a contract, the parties, one or both parties, wish to modify an existing contract in a kind of one-sided way. And what we said was that if you are going to sort of increase the consideration on one side, then you've got to increase it somehow on the other as well, because you can't have someone doing all of these same things they were doing and just getting more for it under the common law. The UCC says, we don't see why that should apply. If you want to change your prices and both sides are willing to do so, you can do that. So I think the book has an example of maybe a brewery has a new beer and they're selling it relatively cheaply to bars in the area, and then it becomes very popular and they want to keep supplying the same amount, but they just want more money, and the customers are okay with that too, then that's okay under the UCC, and that new deal can be enforceable. UCC also has its own statute of frauds. In other words, specifies when things have to be in writing. It kicks in at $500 on the sale of goods. So essentially, sale of goods over $500 needs to be in writing when you're in the UCC realm. There's some, as I put, additional terms and conditions apply. You don't need to know them for the sake of this class, okay? But over $500 has to be in writing. That's what you should know. Now, what happens if things don't go as planned? So I've talked about irregularities in the document or the agreement itself, and how some of those can kind of be smoothed over or filled by the UCC. Kind of the same idea applies when something doesn't go right in the performance. Okay, the UCC again is going to have a smoothing out effect, and it's going to allow for more leeway for the parties to attempt to adjust to a change in circumstances without throwing out the whole contract. Okay? So, when you've got a contract for sale of goods under Article 2, the seller has to tender the goods. What does that mean? It means they have to show up and offer them for delivery and sort of let you look at them, right? A lot of the examples of this, for whatever reason, tend to be around like fresh fruit and vegetables, probably because there's a lot of ways to screw those up. Okay? So imagine you order 1,000 pounds of apples, all right? Seller comes with a truck, they open it up, they're like, here you go, check them out, you know? And the buyer has the right to a perfect tender. In other words, if you ordered 1,000 pounds of apples for, you know, resale for human consumption, You've got a right to that. It's not 800 pounds of apples. It's not 900 pounds of oranges. All right? It's not a bunch of apples that are bruised up and disgusting. It's what you ordered. You've got a right to perfect tender. Now, if the goods come and they don't conform with the agreement, you can reject them. Here's where things get a little different under the UCC as opposed to just common law, okay? Under the common law, if you order 1,000 pounds of apples and I bring you 900 pounds of apples and 100 pounds of oranges, you can just throw your hands up and say, you totally screwed this up, the deal is off, okay? There is no deal, right? You've breached, I have no further responsibility, get out of here, all right? There is a little bit of an opportunity to adjust under the UCC. So if I reject the tender, then you've got the right to cure. Now, you got to cover my costs for shipping, storage, or whatever. So if you say, well, look, okay, I know I only brought you 900 pounds of apples and 100 pounds of oranges, but just take this 900 pounds. Can you store these oranges for me? Those are meant for another customer. I'll be back tomorrow with that extra 100 pounds of apples. Okay? Under the UCC, that would be okay. I would probably have to agree to that, all right? Now, if the cure is ineffective or impossible, that's where I get to sue you. So if you come back the next day and you've got oranges again, then I can say, you screwed up. Okay, we're going to court, right? Now, if, suppose a different scenario, I order 1,000 pounds of apples, you bring me 1,000 pounds of apples, and for some reason I say, no, I don't want to pay for these, all right? So I'm refusing the goods, all right? You could then sue me for non-payment. So in that sense, looks pretty much like the common law, but the ability to cure in the first example is where it changes a little bit. Now, as far as the remedies and the defenses, those are going to be pretty close to the common law ones. Okay, so if it's impossible to perform, like we make an agreement for me to give you 3, 1966 Corvettes, and I had 3 of them, and then the truck crashes, and I can't get them there, right? That would be impossible if I can't get more. Mutual mistake could be a situation. The remedies that you can get, compensatory, so, the cost of the goods that are lost, consequential, that's the lost profits, and incidental damages like storage, things like that. There can be specific performance remedies in the case of unique goods. So if I tell you I'm going to bring you, 10 sets of 1980 baseball cards or something, all right, and then I just decide I don't want to deliver them, the court could say, yeah, you have to sell those. All right. So that is the UCC. We'll get done early today. It's a mind-expanding and mind-blowing experience, I know. We'll come back next time and we'll do business entities. Enjoy the nice day.